to make decisions that involve significant issues of privacy for private parties, privacy for public employees, and others. There are many exemptions in the law, and it's important to make sure that in any new statute or an update of the law, that communities can continue to be able to be reimbursed for the significant time that is involved in reviewing records, including, it could be hundreds of email records, it could be detailed personnel files, it could be police records, and making sure that the privacy rights are protected, but the public also has access to everything that the public is entitled to, which is very important value to local officials certainly hold dear. So the process in this legislation, we are concerned about communities needing to request and receive permission to be reimbursed for their actual costs in segregating and if necessary, redacting information in order to protect existing privacy rights under the exemptions in the statutes. So that's an issue that we'll need to examine, we'll need to talk with local officials about, but that is a concern. The second major concern has to do with the issue of incentivizing threats of legal action against municipalities or any public agencies, state agencies, although we're not the advocate on behalf of state agencies. We're concerned about the impact on cities and towns and whether or not the plaintiff attorneys will see enough of an incentive here to try and to file excessive litigation, especially when communities are simply going throughout the process of for example, fulfilling public records requests under what is accorded and allowed for in state law. And there's language that appears to conflict within the version that is moving out of committee now and going to the full legislature, that language that seems to provide discretion to courts, but actually seems to then significantly collar and constrain that discretion and provide a de facto presumption that in not enough, so therefore that in those the criteria that's outlined in the law is not broad enough, we think, in order to actually capture all the variety of cases and instances that exist. The one size fits all if it's very broad, and misfits all if it's accordioned in and is too narrow. So we're concerned that provision could actually lead to excessive and costly litigation in cases where municipal officials are working in good faith to fulfill public records requests, but are also working to protect the rights of individuals, homeowners, residents, employees who are included in those public records requests.
It sounds to me like you believe on balance that the committee did not strike the right balance between ensuring that the public records law is modernized for the era we live in now and protecting cities and towns from unnecessary burdens that can prohibit them from doing their tasks they were elected to do.
What I'm saying is that in the relatively short time that we've had a chance to review this legislation, we do have concerns, we think real concerns regarding the workability of those provisions and the impact. We know that the conference committee was working to try and strike a balance. We're just concerned about the practical impact of that and whether or not it is a balance the way it would play, the language would play out in the real world.
From what you know now, do you believe this to be an unnecessary burden on cities and towns?
We think that fulfilling public records requests is an important public duty and obligation and responsibility that local officials take very seriously. They need the resources and they need the flexibility to be able to do that. And we're still taking a look at the legislation to see whether the impact itself of this would be too burdensome on communities, but that is a concern.
The committee said they heard from you guys and they extended one deadline from 10 days to 20 days? Wasn't sure which
the committee actually, we have to applaud the process that the conference committee undertook. This is the first open conference committee in a long time, and they actually took supplemental testimony from all stakeholders in what was a bona fide effort to really examine all of the issues. So that was really good. And a part of that discussion was on timelines. And so I think that the timeline that's being referenced here is the amount of time a community has upon receiving an initial request to then petition if they believe, the supervisor of records, if they need additional time beyond the 25 business days that's laid out for the response once a request comes in.
25 business days.
Following the request. So that I believe that there's the question is whether or not originally, I think, or maybe not originally, but in discussions, the question was whether or not communities had to, in the first 10 days, petition the supervisor for additional time, or whether or not they'd have a little bit more time so that they could have a sense of the scope. So, for example, there are frequently requests for a year's worth of emails from a principal or a superintendent. It takes a while for the community to find out exactly how many there are and make an estimate of how much additional time would be needed. And so I think that there was some flexibility added in the bill. Haven't read it yet, but some flexibility added in to give a little bit more time before needing to petition for additional time to comply.
But it doesn't affect the main.
Does not affect the first 10 days.
Okay.
Where there's actually the legislation provides for a very detailed requirement and obligation on public records access officers at the state or the local level to provide a much more detailed response within that 10 days. And then we do recognize too that the legislation knows that municipalities, regardless of the size, just don't have the resources that state agencies have, so there's a little more time in here to comply with that request and the 25 business days compared to the state, which is slightly shorter, and then a slightly longer potential extension period from the supervisor of records.
So that change is included in this, or?
I believe so. Again, I haven't read all 17 pages while sitting here,
Okay.
but glancing at it, yes.
Okay. Great, thanks.
Overall, do you feel what you brought to the community and your concerns are reflected in what you've seen so far as well?
In some parts, we still are concerned about the two major provisions in terms of being able to be adequately reimbursed for the necessary to segregate and redact records, acting in the public interest, and then the second area is on whether the language itself encourages excessive litigation and costly litigation for taxpayers. Great. Thank you.